Welcome to the 21st Sir Anthony Mason Public Lecture. My name is Carolyn Evans. I'm the Dean here at the Law School. And while tonight is a night of the Melbourne University Law Students Society, who have much credit for what's gone on, we're very pleased to be working in partnership with them. I begin by acknowledging that we meet today on the lands of the Wurundjeri people of the Kulin Nations, and I pay my respects to their elders, past and present. The Sir Anthony Mason Honorary Public Lecture was inaugurated in 1995, the year of his retirement as Chief Justice of the High Court of Australia. The lecture celebrates Sir Anthony's outstanding contribution to the legal profession, to the judiciary and to the common law of Australia, as well as offering the opportunity for the students, many of whom I'm so delighted to see here tonight, to hear and meet some of those who have helped shape the law as you study it. The lecture has over the years provided a substantial contribution to legal debate, both within the law school and indeed within the broader Australian legal community. The Melbourne University Law Students Society is just delighted that the Honourable Sir Anthony Mason himself has agreed to present this year's lecture, and both the LSS and the Law School would like to extend great thanks to Sir Anthony and Lady Mason for their time and effort in coming here tonight. It will be the third time Sir Anthony has delivered this lecture, having presented the first in 1995 and the 11th in 2005. And this year, he'll be presenting on the topic of proportionality and its uses in Australian constitutional law. I'd just like to thank and acknowledge the Law Students Society for the work they've done over a very long period of time to make tonight's event happen, and to acknowledge in particular Stephanie Morley and Duncan Burry, the LSS Education Directors, and Bridie Walsh, the LSS Vice President. Also to acknowledge Sharon O'Bell and the events team, particularly Hilary, who've done a lot of work towards tonight, along with Professor Cheryl Saunders and Professor Adrian Stone. I'll now hand over to Stephanie and Duncan, who will formally introduce tonight's speaker.
Good evening to Your Honour, Sir Anthony Mason. Good evening to Justice Marilyn Warren, and good evening to everybody else. I'm Duncan Burry, and this is Stephanie Morley. We are the Education Directors of the LSS, and it is our great pleasure to welcome you all to the 21st Annual Sir Anthony Mason Lecture. The Honourable Sir Anthony Mason was a Justice of the High Court for 23 years, and has received high acclaim for his fundamental contribution to the body of Australian judicial law. Sir Anthony completed his degree at the University of Sydney after serving in the Royal Australian Air Force. Upon completing his articles and working as an associate in the Supreme Court of New South Wales, he joined the bar in 1951. He was appointed Solicitor General for the Commonwealth in 1964, just 2 days before he took silk. During this time, he made significant developments in the area of administrative law, in particular as a key member of the Administrative Review Committee. Subsequently, in 1969, Sir Anthony was appointed a judge to the New South Wales Court of Appeal. However, it was only 3 years before he ascended to the High Court. While on the High Court bench, Sir Anthony presided over a number of landmark cases, such as the Tasmanian Dam case in 1983. In 1987, he rose to the position of Chief Justice of the High Court and went on to adjudicate high-profile cases such as Cole and Whitfield in 1988, Dietrich and the Queen in 1992, and of course Mabo, also in 1992. This is to name a few amongst many other influential cases.
Sir Anthony has remained an active presence both as a judge and as an academic. He sat as a judge on the Supreme Court of Fiji, as President of the Solomon Islands Court of Appeal, and as a long-serving member of the Permanent Court of Arbitration. Sir Anthony also holds honorary doctorates from the Australian National University, from Sydney, Melbourne, Monash, Griffith, Deakin, UNSW, and the Universities of Oxford and Hong Kong. Please join me in welcoming a man of intellect, wit, and insightful observations. Thank you.
Thank you for that more than generous welcome. Tradition holds that when the speaker is invited to deliver a named lecture, as this lecture is, the speaker will begin by delivering a flowery tribute to the person after whom the lecture is named. I shall forego this opportunity to engage in self-boosterism and instead thank you for the invitation to speak and your predecessors for setting up the lectureship in my name. Having delivered the first and 10th lectures in this series, it's a very great honour, if not a miracle, to deliver the 21st lecture. I am particularly honoured by the presence here this evening of the Chief Justice of Victoria, by judges and retired judges, and in particular by a number, perhaps all, of my former Melbourne-based associates who serve with me on the High Court. I'm a little surprised that a number of them now seem to rejoice in the rank of, I shouldn't say senior counsel, Queen's Counsel. In the days when I knew them, I thought they were roundheads. It transpires they're really royalists. Of course, I exclude from that description Professor Simon Evans, who has now risen to the dizzy heights of Deputy Vice-Chancellor. Now, the subject, as you know, is proportionality in Australian constitutional law. Justice Susan Kiefel spoke on this topic, or something like this topic, when she delivered the 2011 lecture. And what I have to say seeks to build on what she said on that occasion. Whether she regards what I'm about to say as building or undermining remains to be seen. Her Honour has been described by one commentator as the High Court's resident expert on proportionality. Even if Her Honour were to disown this description, I'm sure she would acknowledge her keen interest in the subject, an interest which I share. In this lecture, I shall deal with the use of proportionality in other jurisdictions, as well as in Australian constitutional law. This will enable us better to understand the concept and its potential to assist us in resolving our own problems. I shall begin by discussing proportionality in the sphere of administrative law, because that is a cognate area, and it's interesting to see how a parallel development appears to be taking place in that area as well as in the area of constitutional law. And then, before I come to proportionality in other jurisdictions, I shall refer to proportionality as it is understood by Aaron Barak, the former president of the Supreme Court of Israel and one of the greatest jurists in my lifetime in the law. Discussion of the modern use in Australia of proportionality begins with its role in administrative law, where its use as a possible ground of judicial review has been the subject here of ongoing controversy. In the context of judicial review, the possible use of proportionality review has been seen as a possible adjunct to review for Wednesbury unreasonableness or as an independent ground of review. On the other hand, at least until very recently, it was accepted that Wednesbury unreasonableness means so unreasonable that no reasonable decision maker could have made the decision, what is called the Absurdity Standard. So understood, the standard operates as a very limited safety net, catching some cases which do not fall within the other specific grounds of judicial review. While proportionality review is now applied in England under the Human Rights Act of 1998, Australia's been reluctant to endorse proportionality as a ground of review. There were various reasons for this reluctance. One was the separation of powers doctrine, reinforced in Australia by the constitutional separation of powers. The doctrine limits the role of the courts to an examination of the legality of administrative decision-making and prohibits the courts from engaging in what we call merits review. Another consequence of the doctrine was to limit the scope of Wednesbury unreasonableness itself, so as to confine it to the absurdity standard, lest review for unreasonableness would extend a merits review for which specific provision was made independently by statute. In this context, review for proportionality was regarded as taking the courts too close to merits review because disproportionality sets a lower bar and is more easily satisfied. Nonetheless, in 2013, in Minister for Immigration and Lee, the High Court seems to have signalled a softening in its attitude to the Wednesbury unreasonableness standard and a possible willingness to embrace the use of proportionality in judicial review. For present purposes, it's enough to say that there are passages in the joint judgment that seem to support a relaxation in the strict standard of Wednesbury review. There are also passages that suggest that disproportionality is not unrelated to the application of the Wednesbury standard. It is fair to say that Lee, while falling well short of a ringing endorsement of the place of proportionality in judicial review, nonetheless concedes that it has, or may have, utility in some situations at least, under the unreasonableness ground of review. In this respect, Lee is important because it marks a more positive attitude to the use of proportionality in an important area of our law. The same attitude is apparent in Australian constitutional law, though there has been a tendency to favour the expression appropriate and adapted in lieu of proportionality. The High Court has said that the terms are indistinguishable. Further, as we shall see, a higher standard of judicial review may be required in areas of constitutional law than that provided by the Wednesbury Absurdity Standard if we embrace the principle of proportionality. The general idea of proportionality finds expression in various forms. These forms vary according to the particular purpose which proportionality is intended to serve. Even where proportionality is intended to serve the same or a similar purpose, the articulation of the concept may vary across different legal systems and jurisdictions. In the constitutional field, the concept of proportionality, in this context often called a principle, is directed to determining the validity of a limitation or qualification imposed by statute or by another constitutional right or freedom on a constitutional right of freedom or freedom, such as the right to vote or freedom of expression. The validity of such a limitation is determined by its proportionality. The principle of proportionality consists of a set of rules which, if satisfied, determine the validity of the limitation. According to Aaron Barak, the former president of the Supreme Court of Israel, to whom I made reference, and one of the great jurists of our time, a limitation of a constitutional right will be constitutionally valid if, one, it is designated for a proper purpose, a legitimate aim; two, the measures undertaking to effectuate such a limitation are rationally connected to the fulfilment of that purpose; three, the measures undertaken are necessary in that there are no alternative measures that may similarly achieve that same purpose with a lesser degree of limitation; and finally, four, there needs to be a proper relation, what is called proportionality stricto sensu, or balancing, between the importance of achieving the proper purpose and the social importance of preventing the limitation on the constitutional right. This approach to proportionality is sometimes referred to as structured proportionality. It is the presence of the fourth step in the four that I outlined that is controversial. Sometimes the fourth step has been omitted from the statement of principle. The Barak statement of the rules comprising the principle of proportionality is reflected, subject to variations, in the principle of proportionality as it is applied by national and supranational courts. In the discussion which follows, I refer to the principle as it has been applied by the Supreme Court of Canada, the Supreme Court of the United Kingdom, the European Court of Human Rights, the Strasbourg Court, and the European Court of Justice. I can refer conveniently first to both Canada and the United Kingdom, because the formulation of the principle by Chief Justice Dickson in the Canadian case of the Queen against Oakes has been influential, particularly in common law jurisdictions, and it has been taken up very recently by the Supreme Court of the United Kingdom. In Bank Mallet and Her Majesty's Treasury No. 2, Lord Reid, in his dissenting judgment, but a judgment which on this point reflects the view of the majority, said, "The judgment of Chief Justice Dickson and Oakes provides the clearest and most influential judicial analysis of proportionality within the common law tradition of legal reasoning. The attraction as a heuristic tool is that by breaking down an assessment of proportionality into distinct elements, it can clarify different aspects of such an assessment and make value judgments more explicit. The approach adopted in Oakes can be summarised by saying that it is necessary to determine, 1, whether the object of the measure is sufficiently important to justify the limitation of a protected right, 2, whether the measure is rationally connected to this objective, 3, whether a less intrusive measure could have been used without unacceptably compromising the achievement of the objective, and 4, whether balancing the severity of the measure's effects on the rights of the person to whom it applies against the importance of the objective to the extent that the measure will contribute in its achievement. The former outweighs the latter." Now, the correctness of Lord Reid's summary was confirmed in a later case of the Supreme Court in Gayron and the Chief Constable. Lord Reid's summary is another example of structured proportionality. It is important for 2 main reasons. It settled the controversy in the United Kingdom whether the 4th step was an element in the United Kingdom proportionality analysis. And secondly, it marked the acceptance by a leading common law court of the principle of strict proportionality with the potential to influence other common law courts, such as the Hong Kong Court of Final Appeal, and for that matter, the High Court of Australia. Now, there is, I should say, first of all, in Bank Mallet, Lord Reid went on to make the point, as Chief Justice Dickson had made clear in the Queen and Edward's Books and Art Limited, that the limitation of the right under the 3rd Oakes criterion must be one that it was reasonable for the legislature to impose, and that the courts were not called on to substitute judicial opinions for legislative ones as to the place at which to draw a precise line. His Lordship said that this approach was unavoidable, and that to allow the legislature a margin of appreciation was essential if a federal system such as Canada or a developed system such as that of the United Kingdom was to work. So he saw strict proportionality or structured proportionality operating in association with the allowance of a margin of appreciation to the legislature and, for that matter, the executive. There is one other English case to which I should refer. The Queen on the application of Carlisle against the Home Secretary. Now, this was a case in which judicial review was sought of a decision by the Home Secretary to exclude from the United Kingdom, at least to refuse admission into the United Kingdom, of an Iranian dissident who was living in France. an application was made by 16 members of the House of Commons and the House of Lords for her entry into the United Kingdom so that they could discuss with her human rights and democracy in Iran. The application was refused by the Home Secretary on the ground that her entry would be prejudicial to the economic and diplomatic and security interests of the United Kingdom, because it was feared that publication, presumably, of the discussions between the 16 members and the Iranian dissident would result in criticism of Iran and the possibility of retaliatory action by Iran against British economic and other units, and indeed pose a threat to the safety of British personnel in Iran. Now, in this case, the Supreme Court held that the challenge to the refusal of entry failed. In the course of so doing, the Supreme Court held that where convention rights were adversely affected by an executive decision, the court was obliged to form its own view of the proportionality of the decision, and that although proportionality was ultimately a matter for the court, that did not entitle it to substitute its own decision for that of the primary decision maker, or simply to frank the decision without itself considering it, that the degree of restraint to be exercised by the court and the extent to which the assessment of the primary decision maker would be respected depended on the context, that where the decision was based on factors where the court did not have the evidence, experience, and institutional legitimacy to form its own view with confidence, its interference could only be justified in exceptional circumstances, that issues as to the likely reaction of a foreign state and its potentially harmful effects on the safety of individuals and on the United Kingdom's economic and diplomatic interests were matters as a matter of constitutional settlement, which should be entrusted to the executive, which had specialised experience in these fields with a wide range of source material and the necessary institutional competence and accountability. Now, that's a very understandable decision, but it is expressed in such terms that one begins to wonder, is the end result very different from the old view that decisions of that kind were not justiciable? Certainly, the Supreme Court doesn't hold to that view, but there may be a question as to what is the real difference on the ground. Now, from there, I turn to proportionality in the sphere of the Strasbourg Court, the European Court of Human Rights and Fundamental Freedoms, in its decisions on the European Convention. The European Convention contains no reference to proportionality. It was imported into the jurisprudence of the Strasbourg Court from that of the German Constitutional Court. Proportionality made its first appearance in the decisions of the Strasbourg Court in 1976 in Handyside and the United Kingdom, where the court, in considering a legislative prohibition on the publication of obscene material in the context of the Convention's protection of freedom of expression under Article 10 of the Convention, said every formality, condition, restriction, or penalty imposed in this sphere must be proportionate to the legitimate aim pursued. From its beginnings in Handyside, proportionality has become a central feature of the Strasbourg Court's jurisprudence. The criteria applied by the Strasbourg Court are, and there are three, although they can be compared approximately with the four criteria enunciated by Barak. One, whether there's a pressing social need for interference with a protected right. In other words, is there a legitimate aim which is sufficiently important to justify limiting a fundamental right. 2, whether there is a relevant reason for the measure in question. In other words, is the measure designed to achieve the legitimate aim, rationally connected to it? And 3, whether the measure is proportionate to the aim it pursues. In other words, do the means employed to impair the right impose an excessive burden in pursuing the legitimate aim? For example, are the means employed disproportionate to the achievement of the objective? Most cases turn on the third step, proportionality stricto sensu, which is the equivalent of the fourth step in the Barak criteria. One question in this step in the analysis is whether the proportionality principle insists that interference with the right can be justified only when the means adopted represent the least restrictive means of achieving the aim or the most minimal impairment of the right. The Strasbourg Court has not adopted a uniform approach on this question. At times it has used the language of minimal impairment, which it has taken from the Canadian jurisprudence. In general, however, the Strasbourg Court does not require the state to show that the means adopted are the least restrictive. The availability of less restrictive means is clearly relevant because it can support an argument that the interference is disproportionate. In Campbell and the United Kingdom, the Strasbourg Court was not persuaded that it was proportionate for prison authorities to read a prisoner's correspondence with his solicitor merely by reason of the possibility that there was an abuse of lawyer-client privilege. Sufficient protection would have been provided by less intrusive alternative, such as opening mail in the presence of prisoners and in reading correspondence only in exceptional circumstances. I must say that sounds a bit unreal, but that's what the court held. The Strasbourg Court has drawn a distinction between necessity and strict necessity, and in Handyside it pointed out that necessity is not synonymous with indispensable. For this reason alone, it would be a mistake to regard the Strasbourg Court as insisting in all cases on a least intrusive requirement. Another reason is that the court has allowed a state a margin of appreciation in this area, thereby affording the state an element of choice. A least intrusive requirement would deprive the state of any choice. Next, we come to proportionality as it is applied in the European Union by the European Court of Justice, the Luxembourg Court. Proportionality is a general principle of EU law. It is enshrined in Article 5(4) of the Treaty of the European Union, and the principle is expressly referred to in the EU treaties. But the EU principle of proportionality differs from that applied by the Strasbourg Court. As Lord Reid pointed out in the Queen on the application of Lumsden against the Legal Services Board, although there's some common ground with the four-stage analysis explained in Bank Malat, that analysis in relation to the justification under domestic law, in particular under the Human Rights Act 1998 of interference with fundamental rights, is not applicable to proportionality under the EU law. He said that the EU principle of proportionality incorporates two questions. One, is the measure in question suitable or appropriate to achieve the objective pursued? And two, whether the measure is necessary to achieve that objective or whether it could be attained by a less onerous method. The status of a third question, proportionality stricto sensu, is not altogether clear. That is, whether the burden imposed by the measure is disproportionate to the benefit which it secures. Although the court usually omits this question from the court's statement of principle, the court often includes it and addresses it when the point is argued. The court applies proportionality with varying degrees of intensity, depending upon the nature of the case and the category into which it falls. Now I come to the various uses of proportionality in Australian constitutional law. In order to evaluate the use of proportionality in Australian constitutional cases, it is necessary to appreciate that the commonly used expression reasonably appropriate and adapted is to be understood as an instance of proportionality analysis. This is because it contains a requirement of proportionality between the means adopted to achieve a purpose or object and the purpose or object to be achieved. The concept reasonably appropriate and adapted, with its inbuilt proportionality element, is therefore of utility in ascertaining the validity of the exercise of legislative powers which are the subject of a purposive limitation. These powers include the purposive power to make delegated legislation, purposive legislative powers, for example, the defence power, incidental legislative powers exercised alone or in association with non-purposive legislative powers, for example, the exercise of the external affairs power to implement an international convention. Proportionality also has an important part to play in determining the validity of restrictions which may burden the right to vote, freedom of interstate trade and commerce protected by Section 92, and most importantly, the implied freedom of political communication. The concept of proportionality has developed elsewhere as a mechanism mainly for the determination of the validity of limitations on positive human rights and fundamental freedoms. Generally speaking, the Australian Constitution does not confer positive rights. Instead, it mainly imposes negative limitations on the exercise of legislative powers. Despite this difference, the High Court has applied proportionality analysis in determining the validity of limitations imposed by statute. What the consequences of the difference are is not altogether clear, but it may mean that the impact of a limitation on an individual's participation in political communication does not result in invalidity if it is simply incidental to and not an undue burden on the freedom generally. It has been said that there's no role for proportionality analysis in the case of a non-purposive power. True enough, but when a non-purposive power, like external affairs, is exercised for a particular purpose to implement an international convention, the validity of the exercise of the power depends upon the attainment of that purpose, and proportionality analysis is relevant. All this can be gathered from an examination of the King against Burgess and ex parte Henry, the well-known foreign affairs case involving the Convention on Aerial Navigation, and from the remarks made by Justice Dean in the Tasmanian Dams case. In the absence of reasonable proportionality, in itself a relatively low standard, a law seeking to implement an international convention could not be characterised as a law with respect to external affairs. Justice Dean noted that the peculiar or drastic nature of what the law provides, or that it pursues an extreme course, is relevant. But to go back to the Burgess case, there is a passage in the judgment of Justice Stark where he says a wide margin of appreciation is to be allowed to the legislature and the executive in implementing a convention. And I think it's fair to say that that view, notwithstanding the fact that it was in a dissenting judgment, is probably the view that prevails today. In principle, a broad approach would also seem to apply to the characterisation of a law enacted to exercise any implied incidental power which is included in the grant of a legislative power. The question arose in Burton and Honan, where Chief Justice Dixon expressed the view that those powers extended to anything reasonably incidental to their complete fulfilment. And that statement's not inconsistent with what happened in Davis and the Commonwealth, where it was said that the legislation went far beyond what was necessary to protect the commemoration of the Australian bicentennial and its symbols. They went well beyond what was reasonably incidental to that protection. Perhaps the most dramatic example of proportionality in Australian constitutional law is provided by the cases on Section 92. In particular, the case of Castlemaine Tuohys and South Australia, where the Beverage Container Act of South Australia rendered the sale of beer in non-refillable bottles commercially disadvantageous in the interests and with the objective of protecting the environment. The major marketer of beer in such bottles was an interstate brewer who produced beer in 3 states outside South Australia. However, South Australia claimed that the legislative regime promoted better control and conserved energy resources. In adopting the same approach as the High Court had taken in relation to the implementation of treaty obligations under Section 5129, 5 members of the court took the view that the legislation went too far. But the legislation, in fact, imposed a very large difference between the 15 cents refund prescribed for non-refillable bottles and the 4 cents prescribed for refillable bottles. And the discrepancy went beyond what was necessary to ensure the return of non-refillable bottles at the same rate as refillable bottles. And the result was that the burden on the interstate brewer went further than was necessary for the attainment of the legislative purpose asserted by the state. The standard of reasonable necessity, a lesser standard than strict necessity, is a stricter standard of proportionality than that applied in some other situations, such as the implementation of treaties. The insistence on a stricter standard is appropriate to the imposition of burdens on what is expressed as a constitutional freedom. The point is that a proportionality test, whatever label you give it, may vary from category to category in the context of the Australian Constitution, where we are not exclusively concerned with the protection of rights and freedoms. Proportionality analysis has been applied to what I will term the implied right to vote, although that is not a very exact expression. The court has initially took the view that there was no right to vote granted by the Constitution, but subsequently in Roach's case, it seems to have come fairly close to that situation. But certainly, in any democratic country, the 2 rights that are regarded as critically important are the right to vote and the right to freedom of expression, particularly freedom of political expression. That is because they are regarded as being at the very core of democratic government, at the very core of the kind of democracy that we have in this country. So in terms of both those rights, generally speaking, courts apply a very strict standard. Now, proportionality analysis in the implied freedom of communication cases takes us closer to the stronger forms of analysis employed by such courts as the Supreme Court of Canada, the Strasbourg Court, United Kingdom Supreme Court, and European constitutional courts. These courts apply strong forms of proportionality analysis because it is more difficult to justify the imposition of burdens on constitutional and statute-based human rights and fundamental freedoms than in other cases. Now, in Lange, a case of which you will all be aware, the High Court formulated a two-question test for the determination of the question of validity of a law impugned because it burdens the implied freedom of communication. The test was reformulated in Coleman and Power, but only in a fairly minor respect. But since then, in Monis and the Queen, Justices Crennan, Kiefel and Bell pointed to the inadequacy of the two-stage test as reformulated in Coleman and Power. They noted that notwithstanding the enunciation of the two-stage test, Lange held that a law will not be invalid if it is enacted to meet some other legitimate end and it satisfies two conditions. One, that the object of the law is compatible with the maintenance of the constitutionally prescribed system of representative and responsible government, and two, that the law is reasonably appropriate and adapted to achieving that legitimate object or end. Their Honours went on to point out that the second limb of the Lange test, as thus stated, involves a series of different inquiries. These inquiries, as stated in Monis, were further refined in their joint judgment in Tajur and New South Wales. As so refined, the first inquiry is whether there is a legitimate object, and if so, whether there is a rational connection between the law and the legislative object. That is, whether the means are capable of advancing that object. The second inquiry is whether the means chosen by the legislature are proportionate to the purpose pursued. The inquiry at this stage is whether there are alternative, reasonably practical means which are capable of achieving that purpose and which are less restrictive in their effect on the freedom. In other words, are the means chosen reasonably necessary to achieve the purpose? If there are reasonable alternatives, the means chosen are not reasonably necessary and the provision is invalid. If there are no reasonable alternatives, then the means chosen will be reasonably necessary, and then the third question needs to be answered. It is directed to the relationship between the means and the maintenance of the constitutional system of government. It is tested by assessing the extent of the restriction imposed upon political communication. In order to reveal there is an undue burden, this stage of the inquiry might require the court to balance the extent of the burden against the importance of the legitimate object. This stage of the inquiry involves strict proportionality. The references in the footnotes affirm that their honours have drawn substantially on Barak's version of proportionality analysis and the European proportionality jurisprudence. Their Honours' comments on the second limb of the Lange test, as so stated, though not previously formulated in the two-stage Lange criteria, are orthodox and are consistent with the way in which the Lange criteria were applied in Lange itself. There, the common law of defamation was formulated in such a way as to be compatible with the freedom which supported representative government. Yet their Honours' comments have not been expressly endorsed by other members of the court. Indeed, in the more recent case of Tajur in New South Wales, no other member of the court adverted to their Honours' analytical framework. Indeed, Justice Gageler in that case set out and applied a different analytical framework, observing this court has not to date adopted a generic proportionality test of the kind used in Canada to determine whether a law burdening an activity within an area of constitutionally protected freedom is reasonable and can be demonstrably justified in a free and democratic society. He went on to make the point that in determining whether a law effectively burdens political communication can be justified as pursuing a legitimate and compatible with our constitutional system of government, the sufficiency of the justification will be calibrated to the nature and intensity of the burden which those means impose on political communication. So at one end of the spectrum, compelling justification may be required, calling for close scrutiny in order to establish that the law pursues an end identified in terms of the protection of a public interest, which is itself so pressing and substantial as properly to be labelled compelling, and that the law does so by means which restrict political communication no more than is reasonably necessary to achieve that protection. At the other end of the spectrum, sufficient justification may be satisfied by demonstrating that the means adopted by the law are rationally connected to the law's legitimate object. This approach, which eliminates any element of balancing and involves different levels of scrutiny, calibrated according to the nature and intensity of the burden imposed, is somewhat similar to the approach adopted by the Supreme Court of the United States. But it is at variance with other members, the approach adopted by other members of the court. For example, Chief Justice French in Tadjour, as well as Justices Crennan, Kiefel and Bell in Tadjour, rejected varying standards of scrutiny as applied in the United States. When contrasted with Justice Gageler, the approach of the Chief Justice and those justices has a stronger focus on the availability of alternative, practicable and less restrictive means of achieving the legitimate end or object. At least it's clear that the failure to adopt the least restrictive alternative will not necessarily entail invalidity in every case, a view which Justice Gageler seemingly would accept and which accords with the European jurisprudence. Balancing is not mentioned by Justice Gageler. On the other hand, balancing the reasonable requirements of the legitimate public interest seems to be a relevant element in determining whether the limitation is justified. Now, in Unions New South Wales, or Unions New South Wales v New South Wales, Justice Keane also criticised the second limb of the Longy test. His Honour said that to the extent that it contemplated the striking down of legislative measures because a different, less burdensome measure might have been available, would seem to countenance a form of decision-making having more in common with legislative than judicial power. And he went on to say, it might be said that where a state law is impugned, the question for the court can only be whether the impugned law can be reasonably said to be compatible with the free flow of political communication, even within the Federation. This approach is similar to, or the same as, that previously advanced by Justice McHugh in Coleman and Power. The comment has been made that it is difficult to see how this method can operate without some balancing of conflicting interests. Now, in terms of ascertainment of the purpose of legislation, ascertainment of the legitimate aim, there have been significant differences in the High Court judgments in the identification of the purpose. Monis is perhaps the strongest example of this because in that case, the difference in the identification of purpose was critical to the divided outcomes. Another example is Attorney General of South Australia and Adelaide City Corporation, although that didn't necessarily produce on its own divided outcomes. The comment that can be made is the narrower the purpose, the stronger the prospects of upholding the validity of the legislation. The ascertainment of purpose has another level of complexity. which was brought out by Justice Hayne in one of the subsequent cases, or not in one of the subsequent cases, in Monis itself, where he took the view that a wider background of history and decisions should be looked at in order to determine whether a purpose was legitimate. But the current view seems to be that a purpose is legitimate so long as it is not incompatible with the protected freedom. Another problem is how do we determine the legitimacy of the aim? But again, I think a wider view is likely to prevail because that at least offers the legislature a significant range of choice. The most important question, however, arising from the cases that have been decided so far, is whether the court should adopt the simple test proposed by Justice Keane, or persevere with the two-stage Longy test, with or without what I call the Gagler variation, or move to the more structured form of inquiry advocated by Justices Crennan, Kiefel and Bell. It is said that the advantage of the more elaborate form of inquiry more closely conforms to the overseas models of proportionality, and that is, I think, true, provides rational justification, a structured discretion and transparency. This is the claim made for the more sophisticated forms of proportionality analysis by Barak. The main criticism of proportionality centres on the fourth step in his criteria, that is, proportionality stricto sensu, and the element of balancing which it entails. The two matters to be balanced are incommensurables, namely the public interest aim and the freedom which supports the constitutional system of government. Barak's response to this criticism is to say that the foundation of the balance is the marginal social importance in fulfilling one principle or aim and the marginal social importance of preventing the harm to another principle. But this response only invites the question, how is this balance to be determined by a court? It is difficult to avoid the conclusion that the answer is largely subjective. It is said that the structured proportionality approach adopted by Justices Crennan, Kiefel and Bell seems to place a premium on the availability of reasonable alternatives. That may be so. It has also been pointed out that the main doctrine applied by the Strasbourg Court to moderate the impact of the proportionality requirement as a factor capable of undermining the judgment of the domestic legislature is the formulation of legal rules. In the formulation of legal rules is the margin of appreciation. I'm not sure that this is so. Whether it is so or not, there is much to be said for the adoption of a similar approach or a form of margin appreciation in Australia, whether we adopt the structured proportionality approach or not. The factors referred to in Bank-Malat and Carlisle may point the way in the future because they concede a large measure of judgment or discretion or zone of proportionality decision-making to the legislature. And that more accords with our traditions, our system of government, and in particular, the separation of powers. It might be said that if we were to adopt structured proportionality, but at the same time build into it something like that margin of appreciation, it could lead to the development of categories and perhaps ultimately of rules. And this is important because the principal alternative to a doctrine of proportionality is an approach based on categories. Categorization is a traditional common law approach to the solution of legal problems. It could justify different criteria for the protection of different rights and freedoms, such as freedom of political communication, depending upon difference in content or the seriousness of the infringement. As Professor Adrian Stone has remarked, the important feature of a categorical approach is that it brings with it more defined standards of review, and it may lead, as she points out, to the emergence of rules. The Longy two-stage test, with or without the Gagler variation, could lend itself to a categorization approach. But it is the fourth stage of the Barak formulation that is the principal difference between categorization and structured proportionality. Although the doctrine of proportionality offers a principled and structured approach to the determination of the validity of limitations on constitutional rights and freedoms, whether positive or negative, it entails the element of balancing. For this reason, a common law categorisation approach may be more attractive in Australia, where, except for Victoria and the Australian Capital Territory, we are confronted, for the most part, not with an array of protected individual rights and freedoms, but with a rather motley collection of negative restrictions on legislative power, together with some rights and freedoms, in particular two important ones. At the end of the day, however, each approach is defensible without having a clearly demonstrable advantage over the other. And I have two concluding comments. They may actually be three, but the note says two. The first is that proportionality analysis may be useful in other areas of constitutional law. For example, in resolving issues arising under the Cable Number 1 principle. The second is that in the area of discretionary decision-making, particularly in relation to the implied freedom of political communication, judicial review based on the Wednesbury Absurdity Standard would seem to be inadequate. And finally, related to that very point, the contemporaneous emergence in Minister for Immigration and Lee and the adoption by some members of the court of a proportionality analysis in Australian constitutional law would seem to be no mere coincidence.